Okay, we are in week 5 of Wills and Estates. We're starting in chapter 4. I have your edition of the textbook, the 8th edition. So we're on the same page, we've got the same textbook, and so we'll be able to just do assignments that are from the book because actually they're very good assignments. Okay, so chapter 4 is about the validity requirements for creating a will, how to modify it, how to revoke it, and what a will contest is. So there's a lot in this chapter. Okay, if we're going to have a valid will, the document itself needs to have certain components. It's got to say that the intent of the document is that this is a last will and testament. It's got to say that there is testamentary capacity, and the testator actually has to know that he or she is actually executing their last will and testament. And then there's a signature or attestation requirement, and that varies from state to state. So let's go from the beginning to the end of those 3 requirements. The first is testamentary intent. You have to know that you are putting together a last will and testament as opposed to a shopping list. You have to know that what you're doing is setting forth what you want done with your stuff and with your children, if you have minor children, upon your death. Now, there's standard language that goes into pretty much every last will and testament, and it basically says, now comes the name of the person, being of sound mind and body with the intent to create a last will and testament. That sentence covers those first 2 requirements for a valid will right off the bat. You are actually saying in the document, this is my intent to create a last will and testament, and you are also putting in the document that second component, which is that you have capacity. You're of sound mind and body. So what does that mean, being of sound mind and body? Can somebody who has Alzheimer's do a last will and testament? Well, I guess the short answer is maybe. What we want is to make sure that the person who is putting together this last will and testament knows what they're doing. You can't have any delusions at the time that you put together your last will and testament. People who have mental illness can't possess testamentary intent. They're just not capable of it. Are there people who have memory lapses, people who have the onset of Alzheimer's? Can they do one? If they are having what's called a lucid interval. And that becomes really tricky. It becomes really hard for an attorney or a paralegal that is helping someone put together a last will and testament to know whether or not they're in a lucid moment or not. Right? I myself have seen people who have Alzheimer's or early onset, and they're perfectly fine, and they're talking to you like nothing is wrong, and then an hour later they'll ask you again, what were you talking about? Or they'll repeat themselves. You really need a physician to say that someone has lucid intervals and has the testamentary capacity. Okay? Most lawyers won't even go near that, because the lawyer themselves can get into trouble if they are putting together a last will and testament and they know, or they should know, that the person really is not competent. Okay? Now, how can you actually have a last will and testament? Can it be written? Can it be oral? Can it be scribbled on a napkin? Kind of depends on the state. We've gone through already the non-cupative, the written, the handwritten versions of last will and testaments. And again, depending on your state, those state statutes will determine what is acceptable in that particular state for a written or non-cupative last will and testament. But all wills must be signed. All of them must have the signature of the testator. The testator, again, is the individual who is giving their testament, right? What they want to happen with their belongings. Okay, their testament. A testament is written by a testator. So the signature of the testator is a must. Okay, if it's non-cupative, if it's videoed, okay, it's them. But if it's handwritten, or if it is typed, or if printed, you need to have a signature. And the signature can be an X. It doesn't have to be a handwritten, full name. If someone can't write their name, but they know what's going on, an X will do. Think about people who have muscular degenerative diseases, so they lose the capability of holding a pen. They're certainly not going to be able to write, even though mentally they know what's going on. Okay? There's also a really good practice that on each page of a printed or handwritten last will and testament, the testator will initial and date every page of the last will and testament. Why is that? Well, we don't want someone to slip in a different page 2 or a different page 7. This way, we know the date that this entire document was executed by the testator, as well as have the ability to see that that testator had at least the option to read that page and then initialed it. Okay? Every last will and testament also has a requirement that we either have a notary attesting to the last will and testament or witnesses. The number of witnesses depends on the jurisdiction you're in. Whether or not you need a notary depends on the jurisdiction you are in. One thing that we require, however, is that the witness is competent and that the witness is not related to the testator. So let's take each of those. It's kind of obvious we want the witness to be competent. If they're incompetent, how can they witness and know anything, right? If the witness is related to the testator, there is a chance that they are exerting some kind of undue influence on the testator because they, through intestate succession, would be able to be in line for some kind of a gift. We don't want anybody who's an interested party in the last will and testament to be able to witness the document itself. It gives them, again, an opportunity to exert undue influence, and it also gives the witness an opportunity to maybe fudge things if this particular will is challenged. When a will is challenged, and we're going to get to will contests in a little bit, the witnesses are there. The purpose of having the witness is to be able to go to the judge and say, no, I was there, I saw them sign the document, they were of sound mind and body, they knew exactly what they were doing. If you're an interested party in the last will and testament, you kind of have a little nudge, a little incentive to say, oh, of course they knew what they were doing, because you're getting something out of the last will and testament. So no interested parties. Usually that means no relatives. Okay? We also want the witness's signature and the witness's written or printed or hand-printed name, because you can't always read a signature, and their address and contact information. Look, we know 20 years from now that witness may not be at that same location, but it gives you the opportunity to try and trace that particular person in case there is a will contest. I know it's a lot easier to find people with Google and all of the resources we have available now, but we still want to make it easy, and so having the printed address, phone number, and printed name just in case you can't read the signature, is what is required. If you have a notary requirement, the notary is actually a witness. The notary will ask the testator, did you read it? Do you understand it? Is this what you want to sign? Is this your signature? And then we'll notarize the document. The notary can also be called as a witness if there is a will contest. Okay? All right, so we have a valid last will and testament. What if 2 years from now, I'm looking at my last will and testament and I say, oh gee, I left my Ford Fiesta to my son and I sold that Ford Fiesta, but I want my son to have another car. I need to modify my last will and testament. So there's a couple of different ways you can modify a last will and testament. It depends again on your state. There's something called a codicil, C-O-D-I-C-I-L. A codicil is basically an attachment that you can make to your last will and testament. Now, some states won't let you do this, but you can attach a codicil that says, hey, I'm going to change that little part of my original last will and testament that deals with a car, and then I have to have all new witnesses or a notary, and it gets attached to my last will and testament. That's a codicil. That becomes dangerous because codicils sometimes aren't stapled to your last will and testament. Sometimes they're hard to find. So what most good lawyers do is they say, it's on a disk, it's on my flash drive, it's no big deal. We're just going to redo your last will and testament. We're going to change what you want changed. The latest will supersedes the earlier will. Okay? So the latest will that you have that's dated is the one that wins if someone comes forward and says, I have a will from June of 2020. Well, I have a will from August of 2022. That one wins. It's the latest one. So doing a new last will and testament by operation of law supersedes, takes the place of any previous last will and testaments that you've done. One thing that you cannot do is something called interlineation. Even if you have a handwritten last will and testament, you may not take a pen, cross it out, do a little caret, write what you want in there, and even date it and put your signature for every change. You can't do that. You can do that in contract law, and a last will and testament is a contract, but for this particular kind of contract, you may not use interlineation. Not permitted. It will invalidate the last will and testament. Okay? So how do we revoke a last will and testament? What if I wrote my last will and testament and I'm like, I want to change it. How do you do it? Well, the first is by a physical act, the second is by operation of law, and the third is by subsequent writing. Well, we've already gone over the subsequent writing, right? If we want to modify it, we do a subsequent writing. The old one is no good. You've revoked your prior last will and testament. Okay? The one that I think is hysterical is by physical act. You can burn it. You can rip it up. You can stomp it into the ground. You can color on it. Those are physical acts. That's what they mean by revoking a will by physical acts. Okay, if you choose to revoke a will, write all over it. It's no longer valid. Rip it up, no longer valid. Burn it, no longer valid. Okay? If you have an operation of law, again, if you write a subsequent last will and testament, that's operation of law. If you remarry after a divorce, you've revoked your last will and testament. Right? If you've left everything to wife number 1 and you've married wife number 2 and you don't do a new last will and testament, wife number 2 is entitled to elect against a will. We also recognize you're not leaving anything to wife number 1 and not wife number 2. That is by operation of law. The last will and testament that you've written, revoked. Okay? What if you lose the will? First of all, your lawyer should always have a copy of your will. But sometimes lawyers die or retire before you do. What do? Well, it used to be that if you have lost your last will and testament, it's revoked. Okay? Let's talk about who can contest a last will and testament. Anybody who is in the first line of succession, if the person had died intestate, has standing to contest a will. A will contest is basically when you go to probate court and you say, hey, my dad was completely gone when he wrote this last will and testament. Therefore, the fact that he didn't leave anything to me and he left everything to my other siblings, I think that this will needs to be contested because he didn't have any capacity at the time that he wrote the will. Okay, so only those people who are in the first line of succession using intestate succession have standing or the ability to bring a legal challenge to the last will and testament. Okay? And so if you're going to lose a pecuniary interest, a monetary interest, a share in the decedent's estate, if the will goes forward, then you can bring a will contest. So what are the grounds that you can use to challenge a will? The first is that the will was not properly executed. It didn't have the right number of witnesses. It's not the right signature. There's no notary if the state requires a notary. So if the signature is not valid, well, then you don't have a valid will and it can be contested. Okay? No notice of the probate of the will was given to the appropriate people. When you probate a will, and we'll get into this in later detail in other chapters, the probate court is required to notify every creditor, either by publication or by letter from the court, and every heir in the line of intestate succession needs to be notified. If they're not notified and they probate the will goes through, you can contest the will. Excuse me. The will or the testator's signature is forged. Okay, fraud is always a basis for challenging any contract, and this is no exception. Okay, this particular will had been revoked. Okay, if you have a later will, you can come in and say, this is the right will, not this one. Or if you can show that there's been a physical act, you have a video of them ripping up the will, or you have another person who comes in and testifies, yeah, they ripped up the will, or they colored all over it, or, it's no longer valid. That would be another basis upon which you could bring a will contest. The will contains material contradictions, ambiguities, or mistakes. So if the will says, I leave everything to my 4 children, and you only have 2 children, that's a material mistake. Okay? Or contradictions. I leave the car to Jason, and then I leave the car to Susie. Well, who's the car go to? It's contradictory. Or ambiguous. We're not really sure what the last will and testament says. Now, this happens a lot more in cases where we have people who are, people who have handwritten their last will and testament, people who have not used counsel to write their last will and testament. Lots of times this is where you have problems, where people decide they're going to get a kit from Staples, and they're going to go through it and they're going to put everything in. And it may have the valid requirements of intent, capacity, and signature, but the body of it is either unclear or has contradictions or material issues where it contradicts itself. It happens. And so there needs to be a mechanism to challenge that so that basically the court can say there's not a valid will here. That's what a will contest is. It's where we are letting the court look at everything and say it's not a valid will. That's why this chapter is the way it is. What makes a valid will? How do you revoke or modify it? And then how do you challenge it? And really the ways to challenge it is to say it's not valid, it doesn't meet the validity requirements, it's been modified or revoked, and therefore it's no longer valid. If it's no longer valid, what happens is the court throws it out and it goes to intestate succession rather than the testator's wishes in the last will and testament. Okay? I hope that makes sense. Do your assignments and your discussion, and as always, if you have any questions, don't hesitate.